5 seconds to go. Start. The present appeal arises out of a suit for partition instituted claiming 8/20 shares in the suit property described in the schedule to the plaint. The appellants before us were the defendants in the said suit and are successors in interest of one Sanskaran. The latter and Chandu are uterine brothers, both being the sons of one Chiruthi who was married twice. Her first husband was Madhavan, within whose wedlock Sanskaran was born. Madhavan passed away some time before the year 1910, though the exact year of death has not been specified in the pleadings, nor it has appeared in evidence. After Madhavan's death, Chiruthi contracted second marriage with Neelakanandan, who was the father of Chandu. The suit property is situated in survey number 56/8 in the village Iravatur in the district of Kozhikode, state of Kerala. The succession law guiding their inheritance applicable before Hindu Succession Act 1956 that became operational was the modified form of Mitakshara law. But this factor is not of much relevance for adjudication of the present appeal. Though the suit was instituted in the year 1985 to trace the source of claim of the plaintiff, one has to trace the title of the property. In the last year of the 19th century, that is 1900, as it has transpired from evidence adduced in course of the trial, the owners of the property appear to be Madhavan, and he, along with his mother Nangali, had executed a deed of mortgage exhibit B1 in the suit on 7th May 1900. As we find from the judgment of the High Court, which is assailed in this appeal, the mortgage deed itself recorded that possession of the property was not given to the mortgagee. The plaintiff claims his share to the suit property from his mother, described in the plaint as owner of the property Chiruthi. We must point out here that the plaintiff also had passed away during the pendency of first appeal, and before us are his successors in interest who are representing his claim of share as the respondents. Those impleaded as defendants in the suit, which was registered as OS number 157 of 1985 in the Court of Munsif Magistrate, were successors in interest of said Sanskaran. Apart from Exhibit B1, 3 other deeds were considered by the respective fora before this appeal reached us. There is a deed marked Exhibit A20, which is described as Kanan Kuzi Kanam deed executed on 14th July 1910 by Chiruthi. On behalf of Sanskaran, who was a minor at that point of time, Chiruthi executed the deed. This was in the nature of a deed of lease. Achyutan was also a minor at that point of time, and the said deed records Cheria Amma, to whom the property was being leased for herself and her minor son. Stop.